What's up, everybody? Welcome into a breakdown of some experts, some voir dire of these experts. What do they know? What is their experience? Should they be able to testify to this jury? Are any of their opinions going to get rejected or blocked by the court? Will any witnesses be blocked altogether? Because that is what the Commonwealth is requesting. We're going to listen to the arguments. We're going to listen to their backgrounds. We're going to listen to some of their opinion, but not all of it, and why Jackson probably wants to keep that out. We're going to answer your questions. Watch it all together, and we're going to just relax. A half day, less than a half day, 2.5 hours of testimony. It's going to be a breeze. We're finally going to have a 1-hour video. I appreciate you all joining me. Hit that like button, and let's get started. So we're going to jump in right at the beginning of this hearing, because I like what Jackson did here, and I think it's really important before a witness takes the stand, especially in a situation like this where maybe you don't even think this voir dire challenge is appropriate the way it's happening from the Commonwealth. You want to know, what's the judge going to allow them to ask? What do you need to prepare to respond to? What do you need to prepare these witnesses to be able to testify to? I'll be honest with you, I don't worry a lot when I feel like I have a good expert. I talk about what their opinions are, why, what they're based on. All that's really important. But when it comes down to preparing them for, cross or to know what's coming, I'm not really that worried about it, because usually they're ready. They're better at answering these questions than I would be in trying to prepare them or get them ready for it. And so I'm just kind of ready for whatever they're going to say, because it's going to be better of an answer than what I could give. So let's start out listening to how Jackson wants to set up these guardrails and why. Why does he want to make sure certain things don't come out during this process? We'll talk about all that.
All right, let's bring her in, please.
Your Honor, before we get started, can I get an understanding? You started to say that a sidebar the other day, you said you wanted to put that off to get to the witnesses. I need a little bit of an understanding of what court's expectations are. My understanding of voir dire, which this is unusual in terms of the timing of it.
So the understanding of the voir dire is this is for the Commonwealth's motion to exclude this testimony. All right, that's what we're here for, the Rule 14 violation.
Is that the same with Dr. Wolf and Dr. Rich?
Well, I thought that would help both of you. The Commonwealth has nothing on that, and you say you haven't been able to even talk to them at all about this case.
That's correct.
So I want to find out if they have any credible, competent evidence to put forward. So we'll have a voir dire on them as well. But
So
for Dr. Russell, what we're doing here today is there's an alleged this appears to me to be a violation of the reciprocal discovery obligations of defense.
So she starts out saying this appears to her to be a violation. That's not good. When the judge says you violated the rules, that's not good.
Counsel regarding Dr. Russell. So let's hear from her today to see what the appropriate remedy is for this violation.
So my intention is to ask her so I have the court understands my sort of guardrails. My intention is to ask her what her qualifications are. That's the basis for voir dire. And that's where I'm going to stop. I'm not intending to ask her what her opinions are, conclusions. I'm going to ask her if she's come to opinions and conclusions, but I don't have to examine her concerning her full opinions or full conclusions, what she's based those conclusions on. It's unfair. We've provided the defense the prosecution, everything that we need to provide to them in terms of disclosure. They've got the equivalent of the report. They've got a summary of what she's going to testify.
When was that provided? My order was 1 week from the start of trial, right?
But we didn't, Your Honor, in fairness, they didn't even finish their discovery 1 week before the start of trial. So it's a little unfair for us to be put on.
1 week from the filing of the certificate of compliance.
Well, I don't know when I can't remember. My co-counsel indications the day before trial.
Okay.
So during the course of the trial is a dynamic thing. During the course of the trial, I did not know who Dr. Maureen Russell was at the time that they filed their certificate of compliance. We then attempted to and did give them the reciprocal discovery that we were obligated to do after they filed their certificate of compliance.
When?
Within 3 days of that. We've been giving them information prior to that, but at least within 3 days of that. We've continued, so the record's clear, we've continued to get additional discovery from the Commonwealth in notices of discovery throughout the trial. They have not finished. In fact, during the trial, they interviewed Jim McCabe, apparently, had a full interview with her. Lieutenant Tully took a report, dated the report, and then they held on to that report until after she testified. The interview, the report, and the completion of the report were all done before her testimony.
Do you need to call her again?
That's not my
So here's what's annoying, okay? And we'll talk about the different standards she has for the Commonwealth versus the defense throughout this entire hearing. But he's like, you want to talk about discovery violations? During the trial, McCabe was interviewed. A report was made before she testified. It was held on to. They didn't give it to us till after she testified. And so we didn't even get to use that report in cross-examining her. Instead of Bev saying, Well, I find that there's been a discovery violation. And there is a discovery violation. That is not okay. And we've got to make sure we fix that. She doesn't say that. She just says, oh, do you want to call her again? You don't care to call her again. That was no big deal. So why are you making such a big deal about it? It's like, okay, no, we don't want to call her again. We're just making the point that we've been pushed through this trial, and it's really not a situation where we have everything ready to go, which is why we wanted to continue, why the state wanted to continue, and you didn't let us, and that's fine. But stuff's going to pop up. And the real question for me is the interests of justice. We do not want an innocent person in prison. If they have evidence of her innocence potentially, now maybe the jury won't see it that way, but if they do, we have to let it in America. If there was a new eyewitness, there are things we can do to make sure they're able to testify in the interest of justice. The victims deserve justice. The defendants deserves justice. The citizens deserve justice. So we have to make sure that we do this right. And if it's a nothing burger, then fine. No big deal with Jen McCabe. But if it's important, we have to make sure that we get this right and we allow people to testify to something that's important. And that's all they're saying.
And I think the court understands. That's not my point. My point is not, I need to call Jennifer McCabe back. I've done the damage that needs to be done on Jennifer McCabe. The point is,
I'm sorry, I missed that. You've what?
I've done the damage that needed to be done on Jennifer McCabe. I don't need to call her back. The point is that what's good for the
He
goose
said, I've done the damage to Jennifer McCabe. We don't need to call her back. But what's good for the goose is good for the gander, meaning if they're missing stuff or if they're responding late, we should be able to too.
good for the gander. The Commonwealth doesn't get to stand in the position of piecemealing and feeding us information, reports, discovery throughout the course of the trial. And by the way, when we then got seminal information about an expert that we did not know about, never met, never heard of, within 3 days of that, we provide everything that we have about that witness to the Commonwealth. They can't then turn around and say, oh, well, it's all the defense's fault. So we want to have a voir dire, which means that the euphemism for that voir dire is we want to have two bites at the apple.
Okay.
We want to be able to completely cross-examine her and go back to our expert. And if she testifies, cross-examine her again after consulting with our expert. That's two bites at the apple, and that's not fair. If the court wants to hear whether or not Dr. Marie Russell is qualified to testify about the arm injuries, that, I believe, is the parameters, the proper parameters of the voir dire, and that's what I'm prepared to do today. But I wasn't planning on getting into the substance of her testimony because that's been provided. And I don't think Mr. Rebuttal should be able to get into the substance of her testimony because he knows what her substance is because, like I said, that's been provided.
All right, so I disagree.
What he's arguing about there, and what is one of the big, sorry, we're having a technical issue again. The super chats are not automatically starring, and the membership stuff. So we're trying to figure that out to make sure I get to all the questions at some point. But his really big argument here is, I don't want the state to be able to depose all of these witnesses, especially right now. Think about the timing. Okay, we're about to get this doctor to come up, and the medical examiners, which are the medical experts for the Commonwealth, have not testified yet. We think they're coming next. So the Commonwealth is going to have the opportunity to depose this expert, talk to their experts, respond to the defense expert before the defense expert ever gets to take the stand. And in most jurisdictions, that's no big deal. Like here in Florida, we're allowed to depose all the experts. No big deal. But in Massachusetts, there's not a general rule that allows you to depose experts in criminal cases before the trial. There are some circumstances where they allow it, but this is not one. So Jackson is really trying to protect that. Now, there are reports that some of these experts have that each side has read, so they know what their general opinion is going to be, but he does not want all of these experts' opinions to just come out. So what does that mean? What's Bev going to do? And it's going to be really interesting what the judge ends up doing and why. Breezy said, Pita, have you ever seen a judge tell the DA what questions to ask? I was actually appalled. Is this an appellate issue? Not an appellate issue. Yes, I've seen it before. Judges help prosecutors all the time. Witsit, sorry I'm late to the party in terms of the trial. I was pretty convinced there was a police cover-up regarding some event in the House pretrial. Has that been sufficiently displayed at this point? It hasn't been proven. It's been displayed. We're definitely thinking about it. We see that that's the point of what the defense is doing, but I wouldn't say it's been proven. Yobi, what shade of orange is that shirt? I believe it's burnt. I believe that's what they call it. Burnt orange, Texas. Rachel, do judges often reverse rulings because they're consulting or seeking guidance from peers, appellate judges, or even Supreme Court judges, or just research? I don't know about change their, once they make an official ruling, it is very unusual for them to change their ruling, but sometimes they may think they're going to make a call and then they come and they hear argument and they don't actually make that call. So that does happen. Nina, just to play devil's advocate, the defense had more than a year to find an expert witness. Why didn't they find her earlier? They read publications. So just wait. We're going to find out why they didn't find her earlier. And again, it's interesting, and the judge has to make a call.
I'm going to hear from the Commonwealth on this. So, Ms. McLaughlin or Mr. Lally?
Your Honor, just briefly in regard to what counsel was referencing with Ms. McCabe, it was not a full interview by Lieutenant Tully. It was a, and I can give, I don't have it on me at this moment, but I can give the court a copy of that report. But essentially it was Ms. McCabe met with Lieutenant Tully, looked at some video, and was asked a single question. That report wasn't available. I didn't have it until after Ms. McCabe testified, but it was given to counsel prior to Lieutenant Tully testifying, and there were no questions asked of Lieutenant Tully in regard to that. My issue, and you know, I wasn't asking for a voir dire as it proposed to, as it relates to Dr. Russell, is that we first heard of Dr. Russell on May 21st, which was, I think, 6 weeks into trial.
Right, so that's what I asked, and you told me it was 3 days after the beginning of trial, Mr. Jackson.
So the judge confused when he said 3 days. He said 3 days after he got the information from her. But what's really interesting is Lally the whole time is making a distinction, and I think it's the proper and correct distinction between Dr. Russell and the two expert, reconstructionist guys. He is saying Russell should be struck altogether because she was disclosed late. Okay. And that's a good argument. For the other two guys, he's just saying, I want to know what their opinion and their experience is because we don't think that they've fully given us everything. Two very different questions. But listen to what the judge does with those two questions and how she helps the prosecution.
I said this to Cyborg the other day. I just said it again today. I let the Commonwealth and the court know about Dr. Maureen Russell 3 days after I learned about her, which was the 17th of May. I think it was the 17th of May. I had never heard of her. I didn't know who she was. We made contact. I determined she would be useful for the jury in terms of the specific injuries to Jonathan's arm. I didn't have one conversation with her. Then immediately, within 3 days of that, turned that information over to the prosecution. So I didn't say that I gave this over 3 days of the trial. That's not what I said.
All right, but you were ordered to do it. Ms. Giannetti, what was the date? You had 1 week from when?
The day before the trial. So we're going to leave April 15th. So what we knew as of that date, we required to know.
All right, I need to take a quick recess.
What? All right.
She takes a quick break. We're going to break with her here and jump up to a couple minutes ahead of time when she comes back and makes her decision.
And I'm quoting from the notes, the importance of this, the reporter's notes to the old rule. And as you all know, we're in the process of updating that rule. But the very integrity of the judicial system and public confidence in the system depend on full disclosure of all the facts within the framework of the rules of evidence. To ensure that justice is done, it is imperative to the function of courts that compulsory process be available for the production of evidence needed either by the prosecution or the defense. So what we're here to do today is decide a remedy for this violation. And that's why we're having a voir dire. I am not prohibiting the Commonwealth from anything on their examination of witness, Mr. Jackson. The alternative is she doesn't testify. So,
wow, what a great option for the defense. Either your expert is struck or he gets a free deposition and he gets to just ask her anything. So guess what? That's what he's going to do. That's what he's going to do.
the Commonwealth has not received the appropriate discovery from this witness. So we're going to have a voir dire, and they can ask her anything that they think they need to ask her. So those are the parameters of this meeting.
As long as I know the guardrails, that's fine. I just
Now, here's the really interesting part. While that's beneficial to the Commonwealth, and that is, a big strategic, not one-upper, but something that they can use, right? And we've been in situations like this too, where we use things as a free depot, and that's fine. But what's really interesting about this, and Jackson didn't really make this argument at the end, but I think the defense's best argument for letting this witness in now is they've completely remedied the discovery violation. The judge read the rule. We need discovery to be on time, so there's no surprise, there's no hide the ball, there's no situation where the Commonwealth or both sides didn't know about an expert or what this expert or person was going to testify to, and they just show up in the middle of trial. How do we solve that? Put them on the stand. Let the Commonwealth ask whatever question they want, and then at the end, we're going to hear the judge say, Mr. Lally, you take as much time as you need, and you can have a rebuttal witness if you need a rebuttal witness. You can do whatever you want to respond to this witness if I let her testify. All of those might be indications that she's going to let Dr. Russell testify. There are other indications where she says she's not. I have a good idea of what I think is going to happen. Obviously, I could be wrong, but we'll kind of save that to the end where we can hear all the exchanges back and forth.
Close the loop on the record. My understanding, and this Little can probably speak to this more intelligently than I can, but during the middle of trial, there was a witness that we had never heard of, we did not know, didn't have a report for,
Who is that?
Dr. Fowler, Faller.
Okay.
If the court remembers, is buried in the middle of about 75 witnesses. So he testified to alcohol levels, et cetera, and protocols at the which institution? At Good Samaritan. But we didn't have that information either. We didn't throw a fit. They said we were going to provide this information in a timely fashion. As soon as we know we're going to call him, be on our witness list. We didn't know one way or the other what he was going to say. We didn't have a report, and we went on about our business. That's what we were doing as well. And by the way, I would note that the notes and report under Rule 14 require disclosure of information you have. I just don't want the court to think that we were sitting on information that we didn't turn over.
No, I'm not saying that. It's just, this isn't as if it was something that the Commonwealth brought up and you needed to scramble. This is entirely of the defense position. So,
I understand.
all right, so that's the big difference. So why don't you go ahead and call her?
Okay. Yeah, excuse call.
Yes.
So basically, he wants to make sure that the rules say you've got to disclose what you have. We've heard this in Koberger. If you don't have it, you can't disclose it. When they had it, they disclosed it. Okay, good point. So let's talk about Dr. Russell real quick. Education and experience-wise, went to MIT, kind of. I saw a lot of people pointing that. I think she went there for like a year and then stopped. She's a retired ER physician, former Boston cop, worked hit and runs, got her BS at Northeastern, UMass MD, worked at the ER, the coroner. She was a professor, focused on animal attacks, published on animal attacks, which is pretty wild. It focused on LEO, law enforcement, dog bites and injuries. She's treated hundreds of dog bites between 500 and 1,000. That's about as good of a resume as you can have for somebody you want to testify to this stuff. If not for the discovery violation, she would absolutely, locked and loaded, be approved to be an expert on animal injuries. Absolutely. So the only way the Commonwealth keeps her out is if it is a discovery violation. Now, here's my thoughts on discovery violations, right? Because I hate them. They piss me off. I hate when one side violates discovery. If it's new information they could not have known before, that's one thing. Could they have known this before? Maybe. I think there's a question about that. But the main point in the interest of justice is you cannot have a discovery violation, something that is late disclosed where the other side can't prepare for it, can't respond to it. It's just too much. This is an argument they knew the defense was going to be making. They have already put forth that there was no canine DNA. So the defense is responding to Commonwealth evidence, which to me is more of a reason why this testimony should come in. And now that they're going to have the chance to basically depose her on the stand, it's not going to be a surprise. They still have time to prepare. They have days off this week, half days, multiple weeks left in this trial. So to me, where is the prejudice to them in this late disclosure? Because that's the real point, is weighing and balancing the interest of justice with how much somebody's prejudiced with this discovery violation. And was it an intentional discovery violation? Did they have it? Did they hide it? Did they spring it on them at the last moment? And that's what we're going to try to figure out in this hearing. Those are some of the big questions for the judge. We're going to jump ahead to basically her opinion.
January 29th, 2022, correct?
That's correct.
Based on your review of all of those materials, were you able to confidently come to any conclusions or opinions about the nature of the injuries suffered by John O'Keefe, specifically as they relate to John O'Keefe's right arm?
Yes.
What is your opinion and conclusion concerning those injuries?
Those injuries appear to be consistent with an animal attack.
Can you be more specific in terms of the type?
For just that testimony alone, if the jury buys it, it's a wrap. The Commonwealth loses all credibility and the ability to prove this case beyond a reasonable doubt. If they even find that it's reasonable that that's what caused the injuries, it's over. This case is over. Can she explain it? Can she show us how and why it is reasonable to believe this theory and opinion?
Of animal, or are you relegated to simply an animal attack?
Well, they are consistent with a large dog attack. There's a combination of both what I consider bite wounds and scratch wounds on the arm. There were also some puncture wounds in that shirt.
And on,
So I'm sorry, puncture wounds in the shirt?
Puncture holes in the shirt.
and on what do you base the opinion that the injuries are consistent with dog bite or scratch marks?
Well, the patterns. There are several patterns of parallel wounds that appear to be superficial scratches that could have been caused by nails or could have been caused by teeth. They're at different angles on the arm and different locations on the arm, and but they're generally oriented in a specific direction. And there's also an area, the distal forearm, which is close to the wrist, which shows what I believe is an arch area of teeth marks.
And what's the significance of the arch area?
Well, so the arch would be the front area of the jaw of the animal, or the dog in this case, where the teeth tend to be close together and curved. There's a curved pattern to the configuration of the teeth.
Let me have just one more.
Yes.
So then they're going to show some pictures.
Hold on.
Yes.
And by the way, this is exactly, and just for anybody who wants to say, this isn't fair, you're holding one side too high of a standard, one side, not the other. This is exactly what we've been begging for from the Commonwealth. Some expert put the picture up there. Let me see you explain exactly how the light and the gashes and the jagged parts of the light line up with the scratches, why this makes sense, how it could be puncture wounds. Please explain that. Because in these pictures, you can see that some of these are, in fact, puncture wounds. And now she's going to explain which ones specifically line up with teeth and puncture marks.
One of the several photographs that you reviewed and coming to your opinions and conclusions.
Yes.
I want to ask you a couple of questions about this. There should be a laser pointer on the desk.
Okay.
Can you explain to the jurors what it is about the injuries that assisted you in coming to your opinion and conclusion that this is from an animal attack?
Okay, there's several patterns here. So for instance, let's look here right near the elbow, the exterior part of the elbow. There's these two linear marks, which appear to be from upper teeth, and two punctures below those, which are superficial, meaning they didn't go very deep into the skin, but they appear from the lower teeth. So that's one pattern. There's another pattern close to the shoulder, which shows parallel marks, these two, and maybe a third one in the middle, parallel marks that are oriented at a certain angle. And these are superficial wounds, which are consistent with teeth marks. They also could be possibly consistent with nail marks, but
With what?
nails from claw, yes. We have some more here, similar from obviously different teeth involved or different claws, and then down here, closer to the wrist, we have an unusual pattern of at least 4 striations, the way I see it, at least 4 striations that I believe are caused from the teeth towards the front of the mouth, near the arch.
I mean, how credible do you find that? Because I definitely find it at the very least reasonable. And if this is a reasonable explanation, that's not good for the Commonwealth. And Grant, I agree, but you know what happens instead? Most of these trials, people hate the presumption of innocence. They hate somebody's right to a fair trial. They hate it when people don't just believe prosecutors and law enforcement officers. And there's a lot of good prosecutors and a lot of good cops. But we have to scrutinize cases appropriately to make sure people are not railroaded. That's why it is so important. And War said, what can lawyers do across America to stop judges and the corruption across America? I mean, fight. People hate lawyers generally. And we've got to be okay with that because the level playing field is supposed to happen in the courtroom. And we have to make sure that we have to fight for our clients. Q, about 10,000 in the chat, 2,000 likes. Let's get that ratio up. Everybody hit the like button. Hit the like button.
Arch. It appears that there's an arch pattern here. So
In a dog attack or in an animal attack, in your experience, let me take this one down. Let's cover the ground on the 3 exhibits that we've already marked. Can we take a look at exhibit 1? Appear to be consistent with what you just testified to in terms of either teeth or claw marks, especially as it relates to the area closest to the elbow.
yes,
And then looking at exhibit 3. May I publish?
Yes.
Is this a close-up view of the area closer to the wrist that indicated those parallel, you used the word striations?
yes,
All right, and these appear to be taken, attended to the autopsy as opposed to the other photograph, exhibit 2, that was taken in the hospital. Is that right?
that is correct.
All right. And would the time difference account for the slight change in the nature of the wound?
It could.
Photograph of the wound, I guess?
It could, or different technique, yes.
Okay, let me take this down. Did you take into consideration the lack, in coming to your opinion and conclusion, the lack of other injuries, for instance, fractures, broken bones, or deep bruising, soft tissue injuries?
Oh, yes.
How did that play into your opinion?
Well, so of course I considered, what else could have caused these wounds, before coming to my conclusion. And
So this part of the testimony here, I'm going to highlight it because this is part of the testimony they discuss later as potentially not allowing her to testify to. They basically say if she's going to testify, she's obviously qualified to testify about the dog bite stuff. But should she be able to testify to the motor vehicle accident, the car crash type stuff? And the judge, in my opinion, tipped her hand that she's going to try to keep out as much as she can as part of this remedy. This is that part. I found this to be very effective and very important. So we'll see.
and so I wanted to rule out other things, and there were no significant major bodily injuries outside the head. There was nothing. There were no fractures of the long bones, the chest, the pelvis, the arms. So yeah. So having seen hundreds and hundreds of car accident victims and people hit by cars, I ruled that out very quickly.
Okay. And in terms
So again,
of,
she just confirmed hundreds and hundreds of car accident patients. So why, I don't understand, would she not be able to say this doesn't look consistent with a car accident injury? But just wait till we get to that conversation. But that's the part I think that they're discussing keeping out, even if they let her testify.
the injuries that you did see, especially as they're attended to the arm, based on everything we've discussed today, is it your opinion, based on a reasonable degree of scientific certainty, that those injuries are consistent with an animal attack as opposed to a motor vehicular pedestrian incident?
Yes.
Thank you.
By the way, he just said to a reasonable degree of, he said scientific certainty, it maybe should be medical certainty, but whatever. He did ask her the standard. That again is going to come up later as a judicial objection, not even a Lally objection, but a judicial objection that she doesn't know the standards necessarily. She just testified yes to it. It was leading, sure. And she says you're not going to be able to lead her, but she did testify to it. And you're allowed to lead in this voir dire situation. All right. So that is the direct. Lally talks about her training and experience at the police academy. He says it was like rudimentary or something like, not that big of a deal. Trooper Paul said, "Hold my beer." And he said the first time she talked to Jackson, they confirmed, was May 17th. Jackson's buddy in the prosecuting office in California where she works knew her. She was working on some other case. She's like, "Hey, I heard about that case over there. I think I could help." He's like, "I actually know the lawyer." They get connected there. Nothing nefarious there. He starts talking about what she did or did not review. And this was interesting. And I want to kind of talk about why this may or may not be important.
So law enforcement canine bites typically involve what we call a law enforcement canine versus a
100. So there are different techniques, but yes, to specifically answer the question, which was, are they generally different from regular domestic dog bites? Yes.
Now, did you write a report in regard to your opinion that you testified to here today?
No.
Why not?
I don't think there was much time, and I didn't know if I was going to be actually testifying.
How long would it take you to write a report?
I wasn't asked to write a report. Excuse me.
Were you asked specifically not to write a report?
No.
He's like trying to make it seem like something nefarious is going on. She's like, "I just didn't write a report." You don't have to write a report, which is interesting.
Now, at any point in time, did you ever look at anything related to Ms. O'Keefe's head injury?
Oh, yes.
So you reviewed reports in relation to that, correct?
Yes.
Do you have any opinions as it pertains to that?
I would rather defer to the pathologist and neuropathologist on that.
That right there, folks, and I'm going to back it up so we can listen again. That right there is exactly what an expert should do. And I love the expert that stays in their lane, only answers when they're sure and positive. That's why I don't worry about good experts. Because if she doesn't know, she ain't going to answer. And she said, "I'll defer to the other experts on that." And the defense can't get mad at her for that. It's like, you just testified to your expertise. Let's listen to it one more time.
Now, at any point in time, did you ever look at anything related to Ms. O'Keefe's head injury?
Oh, yes.
So you reviewed reports in relation to that, correct?
Yes.
Do you have any opinions as it pertains to that?
I would rather defer to the pathologist and neuropathologist on that.
I would have felt like some of the cops were more credible if they would have done that once or twice and not tried to force their testimony in areas they're clearly not experts.
So who contacted you about this case?
I contacted a district attorney that I had worked with in the past, We were discussing a different case, a case that I autopsied in 1995, and I mentioned that I heard that there was a case in Massachusetts that might have been being handled by one of his colleagues, his former colleagues, and that there was an issue of whether something was a dog bite, and that I might be able to help in that case to clarify.
And so when you were provided this material, what is it that you were specifically asked to do?
To look at the wounds and the reports and the materials that were sent to me and render an opinion.
And so before you had even been provided any material, before you had even looked at anything, you had already heard information related to there being a dog bite involved in this case, correct?
I had heard that there was a controversy, that some certain wounds could have been a dog bite versus perhaps inflicted by a motor vehicle. That's what I had heard.
So what I'm really trying to get at, Doctor, is sort of the timeline. Okay, so you hear about this. When was that?
Sometime just before May 17th.
So sometime just prior to that, you hear about some controversy in a case in Massachusetts involving a dog bite. On May 17th, you get reached out to by who specifically?
His name is John Lewin. He's an attorney in the LA District Attorney's Office.
And then who did you talk to after that?
I reached out to him. I said I might be able to clarify. And then he reached out to Mr. Jackson, I believe, and then Mr. Jackson contacted me.
And I'm not asking specifically anything you spoke about, but at some point, the discussion came specifically to dog bites, correct?
So, Yobi, I think that's what a lot of people are thinking at this point. Rain, it is possible for them both to happen, but it's the Commonwealth's burden to prove what happened, and they're saying that didn't happen. So if now the defense proves, or if a juror believes that did happen, I think it's very unlikely that they also find and vote for a guilty verdict. People think that all the time. It's like, yeah, both can be true, but it's like, if they're saying it's not true and you think it is true, you really can't vote with them.
He sent me the materials. He asked me my opinion.
Mention the materials, ask your opinion. When did you provide that opinion?
Probably the next day. Yes, I know it was the next day.
The very next day on May 18th, you provided an opinion?
Yes,
And was that opinion provided in a written fashion, orally? How was that provided?
orally.
So you reached out or to someone shortly before May 17th, spoke to Mr. Jackson on the 17th, received all the material, and then had an opinion by May 18th.
Yes.
But you didn't write any of that down.
No.
Not unusual, by the way. So when he went through all the documents that she did or did not review, some of them was the canine DNA stuff that she did not review. And Yobi, I believe, asked the question, does it affect the judge's decision that the witness did not analyze all material given to her by Jackson, even though Jackson disclosed he sent the material? So, and you're probably asking this question because it sounded like that's a big deal when the judge said it. But in reality, if she didn't review it, she didn't review it. So she doesn't have an opinion on it. There's nothing unethical about that. It can be fodder for cross-examination for the Commonwealth. They can say, well, you have these opinions, but did you know that there are records of no canine DNA? That would be a great point of cross. And that goes to the weight, not the admissibility of her opinion. And so, no, it really doesn't change things. Now, if Jackson lied in emotion, that would be a problem, but he didn't lie. And he answers that question and says, I gave her a Dropbox link. It was in there. I assume she looked at it. She didn't look at it. So then we get to the judge who asks her questions. And the judge basically says, what's your opinion? She tells her opinion. I guess I'll go to her. She does struggle with the reasonable degree of medical certainty. So we'll listen to this. This was probably the worst part of her testimony, answering that question.
To what degree you hold that opinion. Jackson? All right, so since this is a voir dire, I get to ask questions, doctor? So
yes,
I just have a couple of questions for you. I don't think I really heard you. So could you tell me again what your opinion is and to what degree you hold that opinion?
Yes. These injuries in the arm are, my opinion is that they are the result of animal bites or scratches.
And do you know what kind of animal?
Oh, yes, most likely dog, large dog. And I'm very
Now, most likely is, you could quibble with that.
very sure to, what's the word I want? Medical certainty, very
All right, so that
high
this
degree of medical certainty.
reasonable degree of medical certainty.
Yes, definitely.
Okay,
So
and another,
here, to be fair too, to the witness, while she did fumble over that, to a high degree of, there are, in most scenarios in the law, there are no magic words. So if she said a high degree or to the highest degree of medical certainty, usually that would be okay for most appellate courts. It doesn't have to be, the specific verbiage like the judge is making it seem. What's hilarious about this to me is Lally didn't ask these questions. Now the judge is the gatekeeper. And my frustration with her asking these questions is not because it's not important. It is important. We need to make sure she testifies this to a reasonable degree of medical certainty. But Jackson asked her. It was a leading question, but that information has already come in for her to determine as the gatekeeper whether or not this expert should come in. So she went above and beyond to try to see if there were any issues with this expert. So then we get to arguments. Lally says she should be out. She didn't even review what the defense said she reviewed. Big deal. And then Jackson gets up and says, exclusion is the harshest remedy. And to me, that makes a lot of sense. It's like, are we going to jump to just excluding this witness? My overall analysis of this expert witness is she's credible, just for me. She's credible on the very specific area they want her to testify. And she didn't stray outside of her lane, and the defense disclosed it as soon as they got it. So what are we going to do? What do we do with this piece of evidence that we can all agree is relevant? We all agree in the interest of justice should be put before the jury. Are we really not going to allow that in? Let's listen to Jackson's argument here.
Los Angeles County.
So maybe it wasn't clear what I was looking for. I think it was clear. But go ahead, continue with your argument on this.
My point is, Rule 14 requires a sanction if, in fact, the attorney has done something wrong. In other words, it connotes the idea that you're doing something by actively hiding evidence or holding back evidence or not providing evidence that you know you're going to use at some point in an effort to take a tactical advantage. And the sanction for that is exclusion. I've never met this woman.
So you get what he's saying? It's what I was talking about earlier. It's like, it's different if they hide it and they do this on purpose to gain an advantage, and you sanction them to punish them and to punish their bad action. That's not what this is. If anything, it's a negligent delay or a delay they could not have avoided. So what is the punishment really going to be? And the punishment needs to not be too severe because it only needs to correct or fix the prejudice to the Commonwealth. And didn't we just fix the prejudice to the Commonwealth by allowing them to depose the witness, basically get all the witnesses' opinions, get all the witnesses' background, information, experience, and vet all of that? It feels like we just remedied the problem. So why would we strike this witness?
First time I laid eyes on her was during the process after she flew out here to engage this one-year process. She indicated,
Okay, good question. Some people are asking, no, there's no jury in here for this.
Provide some information about this controversy concerning dog bites. I then sent her materials. I talked to her. I sent her materials. I found her to be incredibly credible. I found her to be experienced. And I found her to be knowledgeable in this very specific area, which is rare. There are not that many people who have published, doctors who have published in the area of dog bites specifically. So I thought it makes sense for me to reach out to her and talk to her, which is exactly what we did. And within a couple of days, literally, but almost counted by the hours of me receiving her information, we then had a discussion amongst ourselves. Is this something that we want to then present on the defense side, on the defense case, and we turn the information over to Mr. Lyle? I understand that it was well into the trial, but that's not a fault of ours, and I don't think the sanction of exclusion is necessary or appropriate to punish Ms. Reed from having an experienced witness testify in rebuttal to ultimately what Dr. Scorti-Bello and the Commonwealth is going to present in their case in chief. That's what she's going to do. She's going to present contrary evidence or an alternative theory of where those injuries came from to a person. Everybody on the Commonwealth side who can elucidate about this has said those injuries come from a tail light, including Mr. Paul yesterday. We have contrary evidence, and Ms. Reed should be entitled to present that evidence, even though it came late. It didn't come late by any fault of ours, and I don't believe that the Commonwealth has made out a prejudice that they can't overcome. It's late, obviously.
We're not supposed to send people to prison on technicalities. Now, sometimes people get off on technicalities, and while that may seem like a double standard, it's not. And if we know somebody's innocent, we can't let them go, or we can't let them go to prison because of a technicality. We can't. As a judicial system, as a judge, as a prosecutor, you can't do that. Not saying that's what this is, but if this is something the jury hears and votes not guilty, we should not want her to go to prison.
Mr. Wiley is a skilled lawyer. There's nothing to say that he can't or hasn't been able to prepare for the cross-examination or for an examination from the jury. I just don't think exclusion is appropriate.
All right. So the second part of this argument, and I'll start with the Commonwealth first. So in your motion to exclude, you also raise Daubert type concerns. So Mr. Lally, is there portions, if I permit her to testify, are there portions, and focus specifically on the part of her opinion where she says, I guess the defense expects her to be able to say she will testify that these injuries are inconsistent with having been struck by a vehicle, road rash, or scratches from broken glass or taillight material. I think you have
So Q said, can you stipulate to a remedy that wouldn't otherwise be available? So I don't really know what you mean, like what specific remedy, but if the Commonwealth allows you to call her and doesn't object to it, usually the judge will let it in.
An uphill battle on that part, Mr. Jackson. The Commonwealth, what are you saying? If she,
The second part of the motion is she shouldn't be able to testify to the car accident stuff. And, of course, she's got to tip her hand a little bit more and say, you've got an uphill battle there, Mr. Jackson, that she should even be able to testify to this.
if she testifies, what should she be able to testify to? And don't just say nothing. I want some input.
No. If the court were permitted to the doctor to testify, Your Honor, what I would submit would be permissible testimony from a legal standpoint. I have some factual questions in regard to that, but from a legal standpoint, I think the court could permit her to testify as to the injuries that she observed, her work in history in that area, observing prior injuries related to animal attacks and whatever consistency she believes that they have with that.
So he even agrees. If she's allowed to testify, there's no real getting around her testifying about the animal injuries. So Joanne, this is outside the presence of the jury.
I do not think it would be proper to allow this witness to testify or opine anything about the inconsistency with regard to pedestrian injuries. I don't think any proper foundation has been laid for there, whether it be through experiential knowledge in relation to that, or any sort of specialized training or knowledge, or anything to do with that. Anything.
So what's funny about that is, number one, compare it to all the Commonwealth experts. She's way more qualified, number one. Number two, I would argue the animal stuff is more of a different specialty that everybody doesn't have. So I get why we're all highlighting that with this witness, but she actually probably has more experience and expertise dealing with car accidents and injuries from car accidents than she does from animal accidents, just by the sheer fact that there are way more car accidents and injuries than animal caused injuries. ER doctor, coroner's office, working as a cop, which is basically all the other cops. She marks off, she checks that box. All the other cops were experts to car accidents because of just working on there. So I'm not following how she has the expertise for the animal stuff, but not the car accident stuff. It sure seems like she does have the expertise for the car accident stuff too.
From a forensic pathology or anatomical pathology perspective, I think should also be out of bounds and excluded with regard to this witness. She's certainly a very experienced emergency room physician. So anything in relation to that, I think is permissible. But as far as the experience when it comes to motor vehicle crashes or pedestrian crashes, of which the court is well aware, there are a litany of different types of interactions a pedestrian can have with a motor vehicle in a collision sequence. And simply saying, well, there was no injuries to the leg, so it couldn't have been a motor vehicle collision is just plain wrong, and not backed up by science or anything else that this witness can testify to from the very limited experience she has in that realm. So if the witness were...
Think about Trooper Paul's, and this is what Ben said, think about his testimony to what he and what Lally just said. That's totally wrong. That there's no car. It's like, kind of like he said, how the scratches appeared is totally wrong and makes no sense either.
Able or permitted by the court to testify, I would submit that her testimony should be relegated to simply what, if any, opinions, her experience, obviously, and then what, if any, opinions she draws with regard to the causation of the injuries on the right arm, as it pertains to consistency there. But I venture to guess that it's likely that those are probably also going to be, in her opinion, consistent with many other causes beyond that, if she's being reasonable.
All right, Mr. Jackson.
Also, then, Your Honor, I have no issue with, I have no issue with limiting the testimony to the animal.
I wish he wouldn't have done that. I wish he wouldn't have said, I have no issue limiting it, because I thought her saying this was not, I ruled that out quickly, that this wasn't a car accident. I thought that was effective. But what they're probably doing is trying to get the judge to split the baby, let her testify to the animal injury, take away the car accident stuff. And from my perspective, that's where I feel like if I had to put money down, that's what I think is going to happen. She's going to be allowed to testify, but it's going to be limited to be about, animal injuries and not about car accidents and not about the head. That's my guess as to what the judge is going to do.
Attack issue, the dog attack issue. I didn't, as the court noted, I didn't spend any time. I think I may have asked one question since the motor vehicle incident. I have no problem if the court wants to limit her testimony to the dog bite aspect and not the motor vehicle aspect. I wasn't planning on going into that aspect anyway. I've got another pathologist who can do exactly that.
But you did go through it with her, and it's on your disclosure.
It is, but I have no problem editing.
So why is it on the disclosure, or where the Commonwealth turned over, that she viewed all reports associated with Chloe's bite history in the UC Davis DNA testing? Why is that in there?
Because we sit that in a Dropbox. We set everything in a Dropbox, and I assumed that she reviewed it. She must not have seen it or opened it or reviewed it.
I'll tell you what this tells me. These witnesses are not overly coached, right? He doesn't even really know what she reviewed. Not great, but also he didn't sit there and tell her what to say with each document. So it kind of cuts both ways.
That's what was sent to her. Everything that's in the disclosure is what was sent.
Right. If she's permitted to testify, you led her through quite a bit today. You won't be able to. I mean, she struggled with to what degree of certainty she held an opinion. She struggled to what she viewed. She didn't write a report. I have to consider all of these things too, as the gatekeeper, as to whether she can actually assist the jury. So I'm not deciding this right here. Mr. Lally, if I do permit her to testify, I will give you time to absorb this testimony and to find an expert in rebuttal for this. How long might something like that take?
She's like, I'm going to make sure I give you enough time to find an expert in rebuttal. How long will that take? I think she's trying to set up other issues here.
Not terribly long, Your Honor.
But Lally's like, we should be good, Judge. It's no big deal. It's not that prejudicial for us. Okay.
As far as preparation, I can't give an exact time frame on that. As far as a rebuttal witness, I'd say a week at the most.
A week from today?
Yes.
Why don't you start looking at least? All right. Well, I decide I won't know until Thursday.
Because if he would have said it's going to take me a month, Judge, there's no way I could respond to this, which maybe would have been what I said. It's like, Judge, I'm preparing for trial. There's no way I can stop and find a witness to respond to this one. It's so prejudicial. It changes everything. It's so much harder. Then I think she would have been like, hey, it's too prejudicial. We can't do it. But that's not what he said.
Sure.
All right. All right. Anything else on this witness?
Submitted, Your Honor.
All right. Next witness, please.
With regard to,
So before we get into these next witnesses, I'm going to hit some questions. Michelle, new to Tampa area, best Greek restaurant, Halas and Tarpon. Tarpon's got the best Greek restaurants, in my opinion. Like Americanized, there's, what's it called? Acropolis in Tampa, I think. It's cool. Yobi, it sounded like the Commonwealth and defense came to an agreement on allowing the witness to testify only to animal bites. Why is the judge still thinking about it? So they're not. She said, don't tell me nothing, Mr. Lally. What do you think, if anything, she should be able to testify to? And that's when he said the dog bites. He did not stipulate to it. He still argued she should be struck altogether, and it's going to be up to the judge. Joe, is there not a level playing field with expert witnesses? Why is Bev asking witnesses about to what degree of certainty they hold their opinions when we had Trooper Paul and with his opinion and stuff? So we didn't see a lot of the pretrial stuff that happened with those witnesses. I don't know what happened, but I think you're spot on that it's not exactly a level playing field. Yobi, could she show another dog picture to compare? So if Chloe would not have been rehomed, it would have been good for the defense to be able to do like moldings of her mouth and line them up to John O'Keefe's arm. And that type of stuff could be really important. There are, there's testing that you can do that should have been part of this, but wasn't. Melanie, why did she question the defense witnesses about conclusions, but not the Commonwealth? So I don't know, again, if there were other hearings where she did do that to the Commonwealth witnesses, but to believe that as the gatekeeper to allow that other expert testimony in, I'd be embarrassed myself. Jessamy, so grateful for your analysis and expertise helping through this. Is it normal for the FBI to just randomly give a defendant expert witnesses that exonerate the defendant mid-trial? Why did they? So this was stuff the FBI is doing this stuff on their own. They're not trying to help the defense. They're not giving the defense witnesses. It just so happens that the unbiased third-party investigation done by the FBI, their expert opinions, the defense loved them. So the defense is like, hey, come testify for us. Timar, in your opinion, are there potential appellate issues if Bev denies the dog bite scratch expert but allowed the dog DNA evidence coming from the Commonwealth? I think there is. I think you've got to let the defendant defend their case, have a fair trial. There was not that much prejudice on the state. Lally's like, it won't take me that much time to prepare. In a week, I can have a rebuttal witness. Guess what? This trial is not going to be done in a week. So he's got time to prepare for his rebuttal case. There's no prejudice, in my opinion, based on Lally's answers. Smill, shouldn't the Commonwealth's goal be to find the truth rather than to just win a case? Yeah. How can they seek to exclude the top experts in favor of obviously incompetent ones? So they're not actually trying to exclude the next two witnesses, and that's the difference. But the judge, on the other hand, is going to help them try to exclude part of what the other witnesses say, and we'll hear that. They really just wanted to exclude this witness, which it was a fair request because she was late disclosed. Why was the judge so hung up about the witness having been a consultant in a Massachusetts court? Armchair lawyer, I think she was just trying to find issues. You don't have to have been an expert in the past anywhere to be qualified as an expert. It obviously helps, but you definitely don't have had to have been an expert in this court. Nirvana, does anyone consider the nephew and his friends? What do you mean consider? Consider them as suspects? I mean, the defendant definitely does. If you mean consider them as far as, not harassing them, of course, I consider that. I think everybody should. War critic, do you think the judge has been threatened or paid to take prosecution side? No. Knowing Karen Reed is innocent because she knows Karen Reed is innocent, I don't think that's what's happening. Witsit, Wasn't there a history of aggression / attacks with the dog? Also, didn't they suspiciously get rid of the dog soon after this? So it's interesting to me. Yes, they did. And that's already come out in evidence that the dog has prior attacks and issues. So it's already there. Of all the possible theories, do you think the Commonwealth was going to come up with he was only hit on the arm pirouette one? I still don't get it. I did not see that coming. Happy Sunshine. Peter, do you think Reed spent $1 million on her defense? Yes. Someone said that in the chat. How probable is it that she spent that much? I would say probable. Jenny, AJ is smart for making the point of highlighting Arca's involvement with the NHL. Boston Bruins is one of the original 6. People care a lot about hockey around here. Yeah, just like I say, military and sports, and they hit both of them with these next experts. And I think that's the right time to transition us into the next experts. And Jackson wants to set the ground rules for them as well.
Wolf and Dr. Richler. This is a different scenario, and I'm presuming that the court is asking for a year on their qualifications.
Well, I want to know who did what. They say we. I want to know who did what.
So is the court suggesting that I go through their entire testimony of exactly what they did, their testing, their opinions, conclusions, the basis of their opinions, conclusions?
However you want to do it, Mr. Jackson, we're here today on the Commonwealth's motion.
She basically threatens him, like, if you don't do it all right and you don't get this stuff in, then maybe I'll keep it out. But he's right. For this type of emotion, and the Commonwealth even agrees, you don't need all their opinions, just their background. And that's what Jackson ends up doing, but it is a risk. He's taking a risk because the judge is basically saying, hey, this is your chance. If you hold some evidence back, I'm only going to decide based on the evidence you put forward.
Realize that. That's not the Commonwealth's motion to depose our experts. The Commonwealth's motion is they're not qualified as actual reconstructionists. I don't need to, and I'm not inclined to give them a free bite of the apple to cross-examine these witnesses twice on the basis of their opinion. I'll go through, I think, to the court's satisfaction. I don't think it's going to take long to figure out that they're extraordinarily qualified to render opinions.
He's pretty confident in their expertise.
But I don't think it's incumbent on me to walk through their entire testimony and give the Commonwealth a free bite of the apple like it's a deposition.
Whatever you want to do. I'm not telling you what to do. Whatever you want to do.
All right. So he goes through his expertise, talks about human factors and accident reconstructionist and all the degrees he have. He's clearly experienced. He's a member of all the right organizations and associations. And then we'll get to the most interesting part of his testimony, in my opinion.
By all of those organizations, is that right?
I'm a member of all those, yes, sir.
Have you authored peer-reviewed articles in the area that we just discussed?
I've authored a number of papers in the field of physics, and one of my most recent.
Or a co-author.
Sir.
Importantly, were you hired by the
Here we go. This is the part I want to get to. Who hired you?
in other courts to testify as an expert in the area of accident reconstruction?
Yes, sir.
Importantly, were you hired by the defense in this case?
No, sir.
Before this morning, you walked into court. You and I ever met face to face?
No, sir.
In terms of the commission that you were asked to undertake in this case, that have anything to do with the defense?
No, sir.
That have anything to do with the Commonwealth?
No, sir.
So a third-party agency hired you and commissioned you, or ARCA, with the responsibility of doing accident reconstruction in this case, correct?
Correct.
The person to my left, this female to my left sitting here, you ever seen her before?
Nope.
You know who she is?
Yes.
How many times have you been qualified in other courts to testify as an expert in the area of accident reconstruction?
I think it's around 20 times to date.
In both federal and state court?
Just state court.
Multiple states?
Yes, sir.
Your analysis conclusions and
So this guy is an expert, and then he's going to say, here, I'll just let it finish.
opinions are completely independent, whatever they are. Those analysis conclusions and opinions in this case are completely independent of the defense and of the Commonwealth. Have I got that right?
It's based on the evidence. That's correct.
And you're not paid by either side here in this courtroom.
Correct.
That's huge, right? I mean, that's pretty huge evidence. They're not going to be able to say it was the FBI or the DOJ. They're not going to be able to say that. That's inadmissible. That's not relevant. It's an investigation. There's no charges. So they're not going to be able to say that. But to say you're hired by an independent agency to do all this stuff, defense didn't pay you, state didn't pay you, that's a big bump in credibility for these witnesses, in my opinion. A lot of people are asking about doing more stuff on the dog. That ship has probably sailed because they didn't even know, where she was before now. But if they had her, they could have done a lot of testing. They could have made molds. They could have done x-rays. They could have done all sorts of stuff, but dog's gone. And that's why the defense was pretty mad at about it. All right. That was basically all I wanted to show of his. On cross, Lally basically asked about some other guy, Klein, that he bounces ideas off of. It seems like they really wanted to make sure Klein wasn't going to testify. It doesn't seem like he's going to. He was not the other guy to testify. Then we get to the judge's questions, which are always interesting in this scenario.
I'm sorry, what I didn't.
Mr. Jackson. All right, so, doctor, I just have one question for you. What specifically were you asked to do?
I'm sorry, what I didn't.
What specifically were you asked to do?
So the agency that retained us gave us a selected quantity of file material related to this case, and essentially left it as an open-ended question. Ultimately, was the evidence consistent with a pedestrian interaction between Mr. John O'Keefe and the Lexus?
An unbiased third party asks these experts with great backgrounds in education experience, what were the injuries consistent with John O'Keefe, a pedestrian accident, getting hit by the Lexus? That's the question. That is the ultimate question for the jury. Whether it was intentional, whether it was accidental, whether there was a cover-up or not, whether there was a conflict of interest, whether it was a horrible investigation, all that stuff, fine. But the ultimate question before this jury is, did the Lexus SUV hit John O'Keefe? So the FBI and DOJ engaged these experts originally.
Okay, you said selected quantity of information. Who selected that information?
As far as I'm concerned, it would be the Department of Justice and the FBI.
All right, and they just
And you know, like, they don't want to say that stuff because they've probably been told, hey, you just can't say that stuff. This is not in the presence of the jury. So just for the judge's edification, they're saying it, but that's not going to come out in front of the jury. I'd be shocked if it did.
gave you what they wanted to give you, as far as you know?
We had no say in what material was handed over to us.
Okay.
That's usually how it works with the FBI and the DOJ. They're like, you can have these documents and that's it. You're not getting anything else. This is all you need. Trust us.
All right. Thank you very much. Any questions based on my questions?
No, Your Honor.
Mr. Lally?
Just briefly,
All right. So then we get to Dr. Rentschler, who is, I mean, this guy is smart. This guy sounds like the experts we have in civil trials. Okay. And sometimes it is a little different, criminal, civil, but he also talked about how he testified in a lot of civil cases, which makes sense to me. Car accidents, truck accidents, things like that. He's testified in a couple other criminal cases about causation of injuries. And he explains how he figures this stuff out, which to me is so important because this is what we've been dying for. This is what I've been expecting. This is what I mean when I say I need more from the Commonwealth's witnesses. This is what it should sound like from an expert.
Auto pedestrian impact, try and make products and environments safer for individuals.
And that's different from what medical doctors, correct?
It is, yes, sir.
Little boy walks into an ER with a broken arm, the medical doctor wants to reset the arm and fix the arm, correct?
That's right, yes.
What does a biomechanical engineer want to learn about the broken arm?
We want to learn how that break or that fracture occurs. I always say that we kind of approach injuries from two different directions. You have an injury occur. After it occurs, moving forward, that's when the medical doctors get involved. They diagnose the injury, determine the best way to treat it. What's the prognosis? As a biomechanical engineer, I kind of take the reverse direction. We look at, here's the injury, here's what's diagnosed. Well, how did that injury occur? You know, how much force do you have to apply to cause that fracture? How did the bone have to be loaded? How did it bend to actually cause a specific type of fracture? So we really kind of approach the injury from two different directions.
Understood. And given that,
That's the stuff. That's the stuff that gets the jury to say, oh, okay, I get it. That aids the jury. That explains how do you get this done in a way that's just not common sense.
scientific approach, oftentimes you can come to conclusions and opinions, scientific conclusions and opinions about the causation of it, correct?
Absolutely. Yeah. I mean, ultimately, that's what biomechanical engineering is how does an injury occur? Why did it occur? And what type of setting did the injury actually occur? What type of loading and what type of kinematics do you need to have this injury actually occur?
Can you tell the court a brief synopsis on the discipline of human factors? What part does that play in what you do for a living?
Well, human factors is a large part of it as well. I mean, from a biomechanical standpoint, we look at the body, we have to know anatomy, we have to know the makeup of the body. And then human factors plays a part of it as well as how individuals respond or what their response is to different types of environments or reactions. It really all plays into looking at a specific event. How did someone react? How did their body move? How was the body loaded? There's all different types of factors that you have to apply. The human factors, kinematics, kinetics, biomechanical, musculoskeletal interactions. It's all these different factors that are really involved in performing an analysis to ultimately look at injury causation.
So when Trooper Paul said stuff, that's what he meant by stuff. This is the stuff that matters. And when you have good accident reconstructionists on both sides, which I've had a lot of trials where there are good accident reconstructionists on both sides, it can be very difficult. And you try to, use what you can to prove that yours is the right one and your theory is right. When you only have this guy versus Trooper Paul, I don't know what his opinions are going to be, but that's going to be devastating. If all these people testify how I think they're going to testify based on today, I don't see how the Commonwealth overcomes it. I don't see how they prove, again, forget about the conspiracy, cover up, the bad cops, bad investigation, the disgusting text messages by Proctor. Forget about all that. If they prove that these injuries are not consistent with getting hit by an SUV and are consistent with getting bit by a dog, it's over. This case is over. If that's how it goes. He gets in his education experience more. He talks about how, he works with the NHL. They call you to help save lives, Jackson said. Worked with the military and IEDs in Afghanistan, stuff like that. Does crash tests. Over 100 times he's testified as an expert. Then Lally asked some questions. He asked him if there was confidentiality, asked which materials he looked at. Did he evaluate the injury to the back of John O'Keefe's head? We'll talk about why that's important later. That's basically it. I mean, Lally is basically a nothing burger. Judge says, what were you asked to do again? He says the same thing. They talk about it was a lot of depots. But then we get into the arguments at the end, which I found to be interesting and telling, because Lally at this point basically is agreeing, that's all I wanted, Judge. They gave me all I wanted. So we're good to go on these guys. That's basically what Lally says. And then the judge comes off the top rope and is like, well, hold on. Let's see if there are other things that we can strike. Hold on a second before we're done here.
Are you on your motion?
Your Honor, what essentially what Commonwealth was seeking and had been seeking was just in reference to that, as far as who did what and who was responsible for what and what were the items reviewed, and is that the totality of it? There's a date on the report. I don't know if that was a date as far as when it was filed, when it was opinion was rendered, when that was provided, what was provided to them in the course of their analysis. So I think very simply what Commonwealth had been seeking for the most part was covered today.
Okay. All right.
That was his argument. She gave him the opportunity. Argue everything you want to argue, Lally. His argument was, we got everything we wanted today. This is all we've been asking for. So thank you, finally, defense, for providing the discovery we've been asking for on these witnesses. We know they're not controlled by you, whatever. We've got what we need. It should be over right there. The defense shouldn't have to argue. The judge should not have to make a decision. It's over. They got everything they wanted. But of course, that's not what happens here.
I have some questions as to the scope of the testimony of the witnesses. So, Mr. Jackson, you intend to have them testify consistently with the report, everything covered in the report, and the conclusions, all 4 conclusions in the report? All right, Mr. Lally, what's your take on this?
He has already given his argument. But now that she's said that, Lally's like, oh, hold on. Maybe she's going to strike part of their testimony, which judges often strike parts of expert testimony here and there around the edges, but not the main piece. I shouldn't say often. It happens from time to time.
I do have an issue with number 4.
So Lally's like, okay, hold on. Let me look at these again. And the judge has said, are you going to let them testify to all 4 of these?
I don't think they're qualified to testify. I don't think either of them is qualified to testify to that. That's more of an area of forensic pathology.
What do you say to that, Mr. Jackson?
Number 4 is, their opinion is, there's currently insufficient evidence to determine the cause of Mr. O'Keefe's skull brain injuries or the circumstances surrounding the event. Well within the scope of their expertise, obviously. I don't think I have to. So
the reason is, what is the significance of the head injury? Why does Lally harp on it? Well, the judge has an issue with number 4, which is their opinion, which Jackson reads here. We'll listen to it again.
You say to that, Mr. Jackson?
Number 4 is, their opinion is, there's currently insufficient evidence to determine the cause of Mr. O'Keefe's skull brain injuries or the circumstances surrounding the event.
So there's insufficient evidence to prove what happened, what caused the head injury. And so that's what they don't want them to testify to. I don't have a problem with it. I don't have a problem with her striking that because there's not enough evidence, but I kind of do like that answer as opposed to just leaving it open. Their opinion is there's not enough evidence, which now I'm kind of talking myself into leaving it in, but whatever she makes the call, they're fine. But the fact that Lally didn't even ask for this, Lally was done arguing, and the judge then pushed to strike part of their testimony, I think is totally, totally inappropriate. Forever Wander said, how afraid should we be of this judge's prejudice? I mean, I don't know about afraid, but it's Bush League. Dewey said, honestly, what is Bev's motivation here? Yeah, I don't love it. I don't love it.
Well within the scope of their expertise, obviously. I don't think I have to beat this dead horse. They are highly, highly qualified to read all 4 opinions. And if the evidence in their opinion, their expert opinion, to a reasonable degree of scientific certainty, which is what's evidence here by the report, is that there is insufficient evidence to determine the cause of Mr. O'Keefe's injuries, then that is an opinion that they are well within their it's well within scope, but it testifies to. That's their opinion.
Yeah, I do agree with him, but I also understand it's just kind of testifying to a lack of it, but a lack of evidence is reasonable doubt. And the Commonwealth isn't proving how that happened. So it's not even like they're rebutting something there. So we'll see what the judge does there. Third, Queen, if Lady Justice really is blind, why are judges so pro-prosecution? A lot of them were former prosecutors. I don't think Bev was. I think she was a former public defender. But I think a lot, the majority of people arrested are guilty. And maybe they just, get on a roll with it and they start thinking everybody's guilty, which is horrible. By the way, we're almost done here. We only have 2 minutes here, and then we're going to play a 1-minute clip about Karen Reed potentially taking the stand. So stick around for that. If you are charged with a crime and Alan Jackson is a prosecutor, who would you pick to represent you if your only options are Lally, Bredehoff, or B. Pro Se? B. Pro Se. B. Pro Se. I know I have a fool for a client at that point, but let's ride. Witsit. Wasn't there a history of aggression attacks with the dog? Also, didn't they suspiciously get rid of the dog soon after this? Yes, I think I already answered that one. Joe, can the defense state in front of the jury that the accident reconstruction witness are not hired by either side? Yes, they can. They can't say they were hired by the FBI, but they can say they didn't hire him. Commonwealth didn't hire him. It was a third-party agency. Lauren, can they compared the other incidents with Chloe, compare the bites to John? So no, that would be going too far with those other incidents, but they did get him in. So supposedly a random dog killed J.O. Is that what the defense is saying? No, since they can't prove it was Chloe, they are trying to say it was Chloe. They are trying to say it was Chloe. And the reason they couldn't do the testing, it's already out there that she has been rehomed. So a lot of these dots can be connected with the evidence. Eric, during trial, is there a way for Alan Jackson to probe FBI experts on the stand to elude the jury they were hired by the FBI without outright asking it? So that would be towing the line of complete impropriety. I would not expect him to do that. Nina, Peter, YSL judge denied the motion for cause. Will you do a recap? His arguments seem to be questionable. What can the lawyers do now? Nina, what a great question. I am going to have my dad on tonight. We are going to post a video breaking this down in detail. The motions, the judge's ruling, all that tonight. So make sure you guys subscribe and hit the reminder bell. Nick, isn't it odd that Bev spent her entire 24-year career working in the Office of the Public Defender? What do you make of that and how she acts during this trial? I have no idea. I'm not going to say she's on the take. I don't know if that's what you're trying to say, or, she's connected to some of these people. People have said, I don't know is the point. I don't know. Mara, curious, Peter, in your personal opinion, do you feel the judge is biased toward the prosecution? Most judges are prosecution leaning. I don't think Bev is an exception to that. Colin, it's my opinion within a reasonable degree of voyeur certainty that the judge gets prosecution happy every time an alternative theory is discussed. Maybe that's the case. Maybe that's the trigger. Donna, wow, real experts with degrees. It's shocking that these people exist, right? Do you think it a mistake by him to disclose it was FBI DOJ when Judge Bev asked? No, it's not in front of the jury. She already knew that. Do you think Lally yielded because of DOJ FBI? I don't think he yielded, period. I think they were timely noticed. So he doesn't have the late discovery argument with these witnesses. Azam, can the other party object during voir dire? Yes, but it's in front of the judge, so it doesn't happen a lot. Bennett, Albert said they know where Chloe has been rehomed. Why not get teeth impressions and compare with wounds? At this point, the trial's already started. Discovery's closed, as you see now. They could ask the judge and see if she'd let them do that, but there are complications with that. And then they'd have to hire experts to explain how it matches or doesn't match. Nina, does the jury understand who hired these experts? Probably not. They'll know that they're third party, not hired by the defense, and that'll help their credibility. I don't think they'll pick up that it was the FBI, personally. Who, if anyone, today's witnesses were a relief, true experts. I agree. How rare is it to have an expert not paid by either side? What will the jury think when they hear this, but not who hired them? So if this was good for the Commonwealth, they may try to say that, but the defense would be like, well, they were hired by some law enforcement agency. It's very unusual that the unbiased third party is represented or is testifying for the defense. Why can't they mention the FBI hired them? Because that would be prejudicial and it's not really relevant. It doesn't prove anything. There would obviously be negative respect to the Commonwealth because of that. And there's no wrongdoing found in that FBI investigation at this point against the Commonwealth. Okay, let's listen to the last couple minutes of their argument and then a 1-minute clip of Karen Reed and we're done.
I think that's their conclusion. Mr. Lally is going to have an expert, Trooper Paul, who's going to differ or has differed in that opinion. So be it.
And I would have kept it out. Remember, I would have kept out any medical part had there been an objection. And when you objected, I sustained the objection.
I think we're talking about two different things, apples and oranges. That's not, Trooper Paul's opinion is that his injury or his injuries, well, I think he said variously that it was blunt force could have come from the curb or it was blunt force because the road was blunt. That was his opinion and he was sticking to it. This is contrary to that. Both of these individuals have come to the conclusion of opinion that the evidence is insufficient to support that determination.
the Commonwealth has given all sorts of possibilities. No proof, but all sorts of possibilities. So this rebuts that.
It's well within their purview to testify to that.
No, if I may, I don't think that's her actual opinion. I initially didn't think of it in
But what was their actual opinion, Lally?
these terms as it's phrased on the cover page of the report. If you look at the actual opinion,
I was looking at the last page. Are they the same on the front and the back?
I think the front is a little more definitive and concerning. The back, I think, more as to it's
We're
consistent
talking about these defense expert opinions.
with a whole multitude of different things. So the fact that I don't really think that's an opinion at all, to be honest with you.
All right, I'll take a look at this more closely, give you a decision Thursday. All right, I did not expect it to go this quickly. We could have had the jury here, but I'm sure you all could use.
And said it would take half a day. I think the judge expected and would have let Lally get into all of their opinions, and that's why she cleared this time. Just a guess. I think if I was going to guess what's going to happen, she is going to let the ER doctor Russell testify in a limited fashion just to the animal injuries. She's going to let the two FBI / accident reconstructionist experts testify to everything except for number 4. So she's going to split the baby with both, even when the Commonwealth wasn't really asking her to do it on the accident reconstructionist. So I do think she's going to let them all testify. I think she should let them all testify to not limit the defendant's right to a fair trial and to put up a defense. And so that's my guess. That's one guy's guess. That doesn't mean it's going to happen. You guys let me know what you think is going to happen. Is she going to let 2 or 3 of the witnesses testify? Is she going to limit 1, 2, or 3 of the witnesses' testimony if she does allow them to testify? And now we're going to jump over to this 1-minute clip of Karen Reed talking about potentially testifying in her own defense and how she's going to make that decision. First, we'll see when KR is found not guilty, can she claim her legal fees back from the state, learning so much from the lawyer here in the UK? Unlikely, it's possible, but unlikely. If she can prove a big conspiracy cover up and the cops did this on purpose, that would be different than just a not proven or not guilty verdict. And sometimes it's hard to prove that unless you have a special interrogatory sent to the jury, which doesn't seem like it's going to happen here. Sparky, they could ask a special interrogatory, do you believe there was a conspiracy and a cover up by a preponderance of the evidence to this jury? I don't know if you can mix that type of stuff in criminal cases in Massachusetts, but I don't know. Might there be some info helpful to the state in the IR testimony? I don't know what this means. Would it make sense to argue in close that the Commonwealth spent so much time with the experts refuting the 227 text versus focusing on how John O'Keefe died? Maybe like a comment or two about how, they were more worried about proving the McCabe's innocence than proving Karen Reed's guilt because they're all in it together. Something like that. Oh, Peter, your reaction and facial expressions listening to this stuff is priceless. I try to control it. Sometimes I can't. Charlie, have you noticed when Lally objects, Bev doesn't like me saying sustained, she'll turn to the witness and ask a question. Did he say that? Yeah, she doesn't like overruling his objections, I think you mean. Yeah, I definitely have felt some of that. Okay, let's hear what Karen Reed has to say about how the trial is going and whether or not she's going to testify.
Their case against you. How do I feel about their case against me? There is no case against me.
After 8 weeks.
After 8 weeks, it's smoke and mirrors, and it's going through my private life and trying to contrive a motive that was never there.
Have you thought about what it would be like to be on the witness stand yourself?
Yeah, I have. I'd like to fill in some holes and correct some lies, but it's up to the attorneys, and they'll make the call probably at the 11th hour, and I'm there or not there.
So a couple things. I don't think she should be giving interviews, my opinion. These attorneys know what they're doing, though, and I'm sure they're advising her. It's the right PR move, and if any of the jurors or family members, I hope they're not, but if they're watching, they would like to see the fact that she wants to testify and right wrongs and fill holes and correct lies. I get all that. It could be done just to, pander to the media or whatever, or it could be legit. I get it. But I've heard people say that's total BS. It's not up to her lawyers. It's up to her. Sure, it's her right. It's her Fifth Amendment right. And she is the one that's going to make the decision. But good clients with good lawyers rely on their lawyers' advice. And I 100% believe she trusts and respects her lawyers, and she wants to testify, or even if she wants to testify, if they say they think you shouldn't and that's best for your case, she will agree with that. And that's what she means by it's up to the lawyers. I mean, that's so obvious. So people to fight with that, it's like, have you ever advised a client in a criminal case before? Because every conversation is like this, and the best lawyers will say, what do you think? I'll do what you say. So sometimes it is up to the lawyers, even though it's absolutely the defendant's right, and the defendant will have to answer the colloquy questions from the judge that nobody forced me to do this. Nobody enticed me to do this. I made this decision on my own with the advice of counsel.
You're lobbying though for your chance to testify?
I'm an outspoken person, and I've never not been able to speak up for myself and my defense, except when it matters the most. I've got to rely on them and their expertise, and I'll defer to the attorneys.
Alan wants you, hon.
And I believe her. She'll defer to the attorneys. Michelle, I sometimes wonder if the judge indulges the state because she sees the outcome and doesn't want the acquittal on her hands. Nutty thinking. I mean, there's no appeal for the state. She doesn't really have to protect the record for them. I don't know. Sammy, how long before Alan Jackson action figure is available for purchase? Not sure. A Sparky, sorry, can these witnesses have testimony helpful for the Commonwealth? Sure, they absolutely could. If they can find stuff in there that's helpful for them, cross-examine them on it. Turn them into your witnesses. Does this trial bother you or set alarm bells off? I've seen a lot of cases go forward that shouldn't. This one's particularly bad with the investigation and how the cops are acting. It does bother me, but I'm glad there's a good defense team. That's what I'll say. I gotta pick yay or nay. If these witnesses say John O'Keefe wasn't hit by a car, was she framed? Those taillight pieces had to get there somehow. So it's not. It can be both. She cannot be framed, but the cops can also get tunnel vision, confirmation bias, think it's her, and do everything they can to push it to be her without there being a cover-up and necessarily being framed. I think that is possible. But if I had to pick, honestly, right now, I shouldn't do this. Don't make me do this. I'm not going to do this yet. Let's wait and let's hear the defense's case before I say if I had to go 51% one way or the other, where would I go? I'll do it eventually. Kai, Lally's dumb and will open the door for the car injuries. It's possible. Azam, Peter, thanks for all you do on the channel. I've been following you for more than 2 years. You make me love the law because I can understand it with your simple analogies. I appreciate it so much. Azam, we appreciate you always being here. Layla, new member here as of a few weeks ago. Found your channel after seeing you cover the Karen Reed on Court TV. So glad I did. Thanks for sharing your knowledge and non-biased opinions. I don't know if Court TV played one of my things. I don't think I was on Court TV. I could be wrong at this point, I guess. I don't know. But I'm glad you're here. Regardless, I'm glad you're commenting, asking questions. It adds so much to our chat. That's why it's the best chat and the best conversation on YouTube, because of you guys and the questions and comments you have. You think like potential jurors. I don't care if you're a lawyer. I don't care what your background is. Jurors come from all sorts of backgrounds. I love to hear different perspectives. I love to hear disagreements. I guarantee the jurors are disagreeing. That's what makes this so interesting and informative to me as well. Zach E. was just talking to my grandfather, who was a Boston cop for 35 years, and asked if he was following the case. He said after Proctor, he is disgusted and stopped watching and said he has no idea this case got this far, makes law enforcement look bad. Good cops are the biggest critics of what's going on here. I'm just telling you. Got a lot of friends that are cops and firefighters, and they hate it. It's kind of like when shady, horrible, bad lawyering. I hate it. I hate it. So we get why. And thank you, Zach, for the question and the comment. All right, that's it. I got to go. Hour and 15. We were really close to 1 hour. You guys are the best. Please hit that like button on your way out. Make sure you subscribe. We're so close to 400,000 subscribers. Never did I imagine that would ever be a possibility. So that's crazy. I appreciate you guys so much. But for this one, that's all I got. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.